Your question.
Okay, so Ms. Gibbs, the reason I'm bringing you out now is that your lawyer is asking for me to give you a PR bond on your failure to identify oneself. I don't know, you know, I have to look at what's going on in your life to see, should we give you a PR bond? Are you a danger to the community? I mean,
Not at all, sir. Not at all. I'm a college graduate. I've got 4 kids I need to take care of. I have a job. I have a vehicle. I have no problem getting to court at all. Like this, the last
Whoa, hold up, this part is crucial. The defendant claims she missed court dates due to a miscarriage, which, if true, is tragic. But the judge is balancing sympathy with public safety. What do you think? Should personal hardships outweigh a repeat offender's track record? Let me know in the comments.
2 court dates that I had with my felony, I had a miscarriage and I was in the hospital, and they're aware of that.
everybody tells me it's little bunnies jumping in the woods.
That's the only thing it was. It was I had a for real miscarriage.
I get it, but you're on bond for a felony endangering a child.
Mm-hmm.
You've picked up 2 fraudulent uses. And now, after those 3 cases, you've now picked up a 4th case of failure to identify oneself. So
They were all in this.
stop.
Okay.
You have the right to remain silent. I just want to know what's going on to see whether we should give you a PR bond, because this is not a revolving door, you know?
I understand that.
Yeah.
I apologize.
So we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay, please.
Thank you. On April 2nd, 2025, the officer was monitoring a neighborhood police radio broadcast. The officer heard a broadcast call for the theft of a department store off of East Sam Houston Parkway in Harris County, Texas. The caller gave a description of the defendant and explained the defendant had just left the store. The officer arrived in the area and found the defendant as she was described by the caller, along with a male individual with the defendant. The officer observed the defendant and the individual enter into a motor vehicle and exit the parking lot. The officer observed the motor vehicle have no front license plate and expired registration. The officer conducted a traffic stop and made contact with the defendant, and the defendant identified themselves as Kathleen O'Brien, date of birth, May 24th, 1982. The defendant stated she did not have any ID card on her person. The officer looked up the defendant by the name and date of birth on the public safety photo, and they did not resemble the defendant. The officer asked for the name and date of birth of the defendant once again, and the defendant gave the same name and date of birth. Due to the photograph not matching, the officer attempted to confirm the defendant's name and date of birth with the mobile FIS that returned the actual identity of the defendant as Candace Lynn Gibbs, date of birth July 16, 1981. Along with a Harris County Sheriff's Office mugshot of the defendant that matched the driver of the vehicle.
So they didn't charge her with a theft?
I don't believe so, Your Honor. Or they did not.
So what's going on with the 2 fraud cases that she has that shows like no bond?
Not sure.
You know anything about those cases, Lori?
No, sir. I know that she went to court on the 15th, 14th?
15th. Yes,
On the 15th I received an email from her felony attorney stating that this was the only case that was holding her in, and to see if I could move her up to get her out.
She said something that they weren't filed, or they weren't, or something hadn't been done where.
Yeah, she said they weren't filed yet.
They're filed. I guess the judge just hasn't signed it yet.
Your Honor, it looks like there was a plea offer made originally for the endangerment of a child. And that plea offer has been made now on the fraudulent use case. That was just, I believe, discussed between the felony prosecutor and the defense attorney.
In this case, Lori, in the fraudulent use case, in her clutch, as they pull them over, she has the identifying credit cards, debit cards of 1, 2, 3, 4, 5, 6.
Okay, pause right here. This is wild. 25 different pieces of stolen identification found? That's not small-time fraud, it's identity theft on steroids. No wonder the judge is losing patience. Fun fact, in Texas, stacking fraud charges like this can easily spiral into years behind bars.
7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25 different items of other people's identifying information. Don't. You are on bond for endangering a child. You pick up 2 fraudulent use cases and now allegedly at a store doing whatever with a failure to ID. I'm not going to sit here and give you yet another PR bond. You know, at some point we have to say when, and now is that time. Your bond, literally $50 to get you out, right? But I can't sit here and continue to just perpetuate this thing over and over and over. All I want is my community to be safe, you know?
I understand that.
So I'm going to find probable
In an
cause.
abusive relationship.
Don't say anything, but got to understand that, just, I'm not going to give her a PR bond for you. I'm sorry. All right. So ma'am, what we'll do now, your felony cases are set for the 30th of April. We can set you for the day after and we'll go from there. Okay. Thank you, ma'am.
That's what we said.
Okay, so Mr. Sherrill, you're charged with terroristic threat. You're facing up to a year in jail and or a $4,000 fine. We have already done probable cause. I found probable cause to go forward with your case. We set a bond. He's made the bond or no?
Yes, he has.
You've made the bond.
Yes.
Okay. So, I am entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Taylor as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? They're not currently together now?
No.
Okay, great. So there's just no,
So,
I don't want to talk about the case.
no, it's not. She still like communicates with like my family and my friends. Like I don't even live here, and it's events coming like my best friend's wedding. I'm going to the wedding, but she's trying to come. So how do I have
Got to be careful.
Here's the takeaway: restraining orders are serious, and one wrong step at that wedding could land him back in jail, fast. Have you ever seen situations where personal drama exploded in court? Drop your wildest courtroom story, or a YouTube link, in the comments. Let's compare chaos.
You know, you're not to have any contact with her, you know,
Sounds like she's using, I don't know if she knows there's a restraining or a protection
She
order.
is using, the officer was a personal friend, so that's why.
Okay, well,
so this merely says that you can't go to or near her residence, right, where she lives, where she works. Don't have any contact with her. The problem is that there's a lot of vindictive people in this life. You know, if you go to the same place that she is and you end up bumping into each other and she says something to you, you know, it's a recipe for disaster. So you have to be very careful. If you go to this wedding and she's there, it's like a ticking time bomb. So you need to be just very careful because I don't know, you know, what kind of person she is. If she's that type of person, you got to be very careful. Because there are a lot of people that will call them and say, hey, this happened, when it's just not true. And if it does, they issue the warrant, and then it's up to you now. You pick up another charge, so just be careful. You know? All I want is just you not to have any contact with her. Don't be in possession of weapons. As long as you can do that, we're cool. I'm going to waive your appearance, so you don't have to waste your time coming to court here as well. Just stay in touch with counsel, and he'll tell you if and when you have to come back to court here. So you don't have to come back and forth every single court date. Just stay in contact, and he'll let you know if and when you have to come back.
I appreciate it.
Any questions?
I guess so.
You live in Baltimore, right? Okay. So for now, what I'm gonna have to do is I'll have you sign a reset with Victoria. We'll have you take a seat in the juror box. We'll get your bond conditions. I'll have you sign it, and after that, you're free to go. Okay? Hi, Anna.
Good morning, Judge. Hi, Bruce.
Yeah.
I've got a couple to talk to you about this morning.
You do the easy ones first?
Well, whenever I have to talk to you, Judge, they're never easy.
That's not true.
Fair enough, fair. But these,
I know. Okay.
the first one is gonna be Wilson Keonje. Start with the less difficult.
Okay.
Can we hear PC on this one?
Is it You say Keontae? Keonjae?
Beyond.
Okay, yeah, of course.
On February 6, 2025, a law enforcement officer was dispatched to an assault at Provision High School. Law enforcement officer arrived and observed 15 to 20 students fighting each other and struggling with staff members and security guards. The law enforcement officer detained a number of students. After the scene mostly calmed down, the female was struggling and fighting against male students who run out onto the floor and rejoined the fight. The law enforcement officer approached the males and told the female students' hands behind their back. The law enforcement officer got closer to the defendant, turned towards the law enforcement officer, put his arms up to stop the law enforcement officer's progress towards the female and said, no. The law enforcement officer grabbed the defendant's shirt and told him not to interfere or he'd be taken to jail. The defendant replied, I will, and remained in the law enforcement officer's path. The law enforcement officer handcuffed the defendant and ordered him to get on the ground and began pushing the defendant towards the ground and told him to get on the ground again. The defendant remained on his knees, pushing out against being pushed. The law enforcement officer pushed the defendant down towards the wall. The defendant pushed up, causing the law enforcement officer to fall to the ground. The defendant righted herself before continuing to struggle with the defendant to get him to the ground. I believe that's the type of, the law enforcement officer righted themselves.
So there's a fight.
Yes, Your Honor.
The officer is asking him to move, get out of the way, so he can do whatever he needs to get done, and he just refuses to get out of the way.
Yes, Your Honor.
Anna?
So it sounds like the interference is my client doing this.
He's impeding the path of where he's trying to go or what he's trying to do,
Okay.
right? I mean,
That's what I have, Your Honor.
is there a body cam on this?
It looks like we do have a significant amount of video.
You seen the body cam? Does it show that?
I have not watched them all because it's quite a bit, Judge.
Okay.
But
I mean, remember, it's a low burden,
I understand.
whole cause, and he's, the officer says, hey, move, man, I gotta get this stuff done. And he's like, no, I'm not gonna move, I'm gonna stay here, just, I mean, I get it's just standing there, but,
Okay.
so look at the video. If you see something different, let me know.
Okay. The next one I have to talk to you about is Torrance.
Come on, Ms. Torrance.
I've spoken with the state, and so there's kind of a couple of things going on. I'm assuming you want to do the BVR first. I've spoken with the state. We are going to ask for a hearing. I'll let the state speak for themselves because
Your Honor, we do not have any toxicology back. We have blood alcohol report, but that is not the toxicology report.
Well, talking about the bond violation
Bond
report.
violation, I apologize.
It's okay.
I apologize.
I don't think the state is prepared to have the hearing today. But
I've got bond violations. The Scram device has confirmed alcohol consumption violations on 3/15/25 at 1:51 p.m., 3/23 at 7:14. Confirmation was received 3/25/25 by the analyst, and it's a third bond violation.
I understand, Judge, but
Let her go.
the rules of evidence apply at a bond hearing, and we need somebody with personal knowledge or somehow to get around that hearsay to do the hearing, and I don't think the state's prepared to do that today.
We do not have anyone here to do that today, Your Honor. I apologize.
Hey, who do we need? What Scram analyst do we need to get down here? So we can, right, so they can testify that what's in the BVR. I'm sending her now for a drug and alcohol test right now as well.
I'm going to send her for the test now.
Right now.
Okay. Okay. Have a seat, and then once they put the order in, we'll have you go over there. Okay.
She can head over before the jury.
Okay. Okay. Go over to 41 San Jacinto. Okay.
And then Anthony, do you see, who do we have that can come?
Yeah, I'm gonna get a name and.
Yeah, okay,
We'll
get it. I'm gonna try to get it today. Okay, well,
And then, so the secondary issue, on Ms. Torrance is we have gotten the alcohol report back. They sent the, blood off to get analyzed for toxicology.
oh Lord, did you just send the blood off?
And Judge, if,
No.
Verify when that,
This case is 233 days old and we have violation after violation. I'm not waiting anymore. She's way too much drama for me and I'm ready to set this thing for trial.
Understood, Your
I'm
Honor.
not doing it anymore.
For the courts, I did email the person on that side, just got a response. Toxicology analysis still in process, pending completion, it's likely requires some time for the lab board to proceed.
Did you just send it?
No, Your Honor. We've been sending follow-ups. This was like a last Hail Mary attempt of, do we have it or do we not? They still have it.
Do you have other things to go on regardless?
I think we have.
No.
Spoke with defense counsel, there is, proper, there was alcohol in the system.
Well, look,
we have-
it doesn't matter to me, however you guys want to do it, but to me, way too much drama. I'm setting this case for trial. That's it, because
Yeah, and he has laid an offer, I just,
I need to talk to her about the offer. If it's not moving anywhere,
Okay.
I'm setting it today.
Okay,
Way
and-
too much drama.
just to remind the court, when I was here last time, you gave them 30 days and said if they didn't have the report, that it wasn't coming.
Okay.
I understand the state has to do its job.
So can you take a look and then, take a look
Absolutely.
and then let's go. But yeah, I'm ready.